We're going to go ahead and get started. Hello, everyone, and welcome to Estate Planning. Before we begin, one quick reminder, please hold all your questions until the end of the webinar. You can type your questions in either the chat box or the Q&A. I'll be looking in both places, and at the end, I'll read the questions out loud to Mark. Our speaker tonight is Mark Lang. Mark started his career as an intern developing computer models in the commodities market. He very quickly learned that this was not the area of his calling, as it did not offer the reward that helping others gave him. This desire led him to join American Express Financial Advisors. During his time at American Express, Mark completed the College of Financial Planning's CFP Professional Education Program and became a training and district manager. Mark then moved from American Express Financial Advisors to LPL Financial. He is a past member of Putnam Investments Gold Scale Council and Goldman Sachs Blue Chip Council, as well as a former host of From Wall Street to Main Street on radio station WTBQ in Warwick, New York. So without further ado, I'll turn things over to Mark.
Thank you so much. It's always nice to have a pretty large audience. Looks like we've got 20 participants tonight for estate planning. So I want to always say thank you for taking the time out of your busy schedules to attend an hour with me. And estate planning is an interesting area because it's one of those areas that when I talk about it, it really covers so many different things. So tonight we're going to do it from approximately a 10,000 foot level. As was indicated before, hold the questions till the end, but when I passed 60, trying to remember those questions was not an easy thing to do an hour later. So if you have them, write them down on a pad or jot them into the chat box and we'll get to them at the end. I always like to tell people why I decided to join SOFA, which I did about 5 years ago. I was trying to find a different way to give back to my community, and I thought that the best way that I could do that was to educate people in the financial arena. Today, although I don't take on new clients, it's one of those things that I feel like I have to give back to people because this area has become so complex, especially with all the new retirement requirements as a result of the defined contribution plans. And most people don't have pension plans anymore. So there's so many things that have to get integrated into this area. But we decided to join SOFA, which is a nonprofit organization that started in 1993 out in San Diego, California. And basically the premise behind SOFA was we wanted to educate our communities, literally one community at a time. We want to improve that financial literacy. So I'm going to pop through a couple of quick slides that are more what I'll call the housekeeping type items. So as I said, I want to thank you for joining me. This is a bit about SOFA. This is an education only. I am not here to sell anything at night or anything tonight. Occasionally, I will use a particular company or product as an illustrative component, not so much in the estate planning area. But when I do that, I don't mention who it is. I just want you to understand the concepts that are attached to it. There's a little bit more about SOFA. And as you can see, the mission is to end financial illiteracy across America, literally one community at a time. If we were doing these live like we used to, I would ask you for an evaluation form. I find them invaluable. It helps me to kind of stay focused on the areas that people find the greatest amount of interest. So without further ado, let's get started. So when I talk about estate planning, what does it involve? Well, it involves three fundamental things. First, planning for yourself to ensure that the wishes that you have are carried out. Second, planning for your children or others who depend on you for support. So if you have a special needs situation, you want to basically take care of these things long before you get to the end of your life, because otherwise you may have people taking on those roles that you hadn't planned on. And it's important that you put those pieces in play as opposed to, for example, the state. And lastly, planning for your family to prevent financial hardships for loved ones. Why? Because in virtually every instance, estates have to be settled within 9 months. And if you don't have a good sound game plan, 9 months goes by like the snap of fingers. So who needs to do estate planning? Well, basically everybody needs to do estate planning, but in particular, anybody that owns real estate or assets. If you own a home and it's a joint tenancy type situation or a tenants in common, or you have a survivor situation, or you live in a community property state, you really have to think about having those estate plans in place long before you pass. And specifically others that are going to depend on either you or your assets for support. So special needs become a real key element when we come to estate planning. So when we talk about planning for yourself, what are the elements that we're talking about? Well, planning for your end of life care, today, hospice and things like that. How do we do that? With advanced planning forms and specifically directives attached to that. Planning for disability or incapacity, and I put LTC in parentheses, meaning long-term care. This is one of the number one elements that estate planning attorneys are going to talk to you about. If you go in and decide that you're going to begin your estate planning journey, they're going to start talking about long-term care, and they're going to do it very quickly. Why? Because longevity is one of the biggest issues that our people, especially in this area, are going to face. The higher the education level, the higher the income levels, what do we find? You're going to live a lot longer, so the probabilities of long-term care become more significant to you. The statistics are as follows. Age 65, once you reach that, the probability of long-term care stay is above 70% for the remainder of your life. Why is it so important? As you can see to the right, designating someone to make decisions for you, and more specifically, who will take care of you? Are they aware of those responsibilities, and are they the right people? Next, planning for the estate taxes and what kind of strategies you're going to employ. Why? Because you want to take care of those that you care the most about. And you want to make sure that they know what those plans are beforehand. One of the designations that will be my final one is one called the Chartered Advisor of Philanthropy. The most important thing that we talk about on a regular basis when we talk about philanthropic elements and or estate planning. Make sure you choose the right people to fulfill the correct roles. If you don't, they're going to need tremendous amounts of assistance, and you need to think about that beforehand. And then ultimately planning the distribution of your estate. Why? Because you want to control when, why, and how your assets are going to be distributed. Very important to do those things. So let's talk about some of the key elements that you're going to put together. One of the first things you're going to talk about is what's called an AHCD, which is an Advanced Health Care Directive. What does it do? It's a form that helps to ensure that your wishes are carried out. You can select a primary physician. You can designate a specific person to make medical decisions for you if you're unable to make them for yourself. It also makes your choices regarding the kind of medical care that you wish, and it communicates them not only to your loved ones, but also to your physician. And it communicates your wishes regarding any organ donations. So very important to think about those advanced healthcare directives. It will be a foundational element of an estate plan. Another one that you may encounter is what's called a POLST, or a physician's order for life-sustaining treatment. What does it do? It gives the doctor orders and is recognized throughout the medical community. If you don't have one ahead of time, and especially if you don't have an advanced healthcare directive, if you go in for surgeries, they're typically going to give you a form that basically says, what would you like to do? And you're going to have to check those things off in many instances before you even go in for surgery. What does this particular form allow? Well, it states whether you wish CPR, choose which medical interventions you wish to receive. In other words, do you want full treatment? Do you want limited treatment, or comfort measures only? This is significant. For myself, when my dad finally went into hospice, we wanted comfort measures only. We didn't want full treatments and things like that. My dad had gone through a significant bout with cancer, and we wanted him to go through with dignity. And that was what my pop wanted. So we made sure that those things were in writing long beforehand. And it also states whether you wish artificial administered nutrition. That, in many instances, is one of the things that people do have a tendency to cut off, especially when they get into the hospice elements, because they want people to not have to linger through that particular period of time. Also, you may have what's called a DNR, which is a do not resuscitate order in the event of a cardiopulmonary arrest. Okay, and what does that form do? It instructs any emergency medical personnel regarding the decisions to forego resuscitative measures. So what are the typical types of treatments that could be withheld? Chest compressions, assistance with ventilation, endotracheal intubation, defibrillation, and cardiotonic medication. So you want to make sure that you put these things into play in your documents beforehand. Planning for disability or incapacity, as I said before, this is the #1 area that you're going to see estate planning attorneys talk to you. Why? Because the advances in medicine have increased the likelihood that many of us will need someone to administer our affairs. Why? Because of the fact that we're living so long, what are the 3 common elements that people are beginning to see? Alzheimer's, Parkinson's, and dementia. You want to have a prescribed path for those things. And if you don't, planning for disability or legal incapacity helps to prevent probate or conservatorship and confusion amongst your loved ones during that difficult time. So you really want to think about these life-ending elements long beforehand. Please don't wait until it's thrown in your face. I promise you, these will be very confusing times, and you want to try and address these as soon as you possibly can. What is conservatorship? Because a lot of people will ask me that. They're not quite sure what it is or how it works. Well, what we're trying to do here is to determine whether or not you're competent in the event of a disability or legal incapacity. Why do we want to do that? Because if we find out that that is the case, the probate court holds a public hearing to determine whether conservatorship is necessary. And if you're found incompetent, a conservator will be appointed by the court to manage your affairs, not by you, by the court. The probate court and the conservator, not your family, will now manage your affairs. Why is this significant? Well, #1, it's very costly. 2, it's public. 3, it's very time consuming, and it continues all the way until death. So you really want to think about these things ahead of time and have these checks, so to speak, in place beforehand. Do you need a will? Well, if you don't have any assets, you probably don't have a need for it. But if you live in the New York metropolitan area and you've accumulated a sizable amount, you may need a will. Or you could pass away without one, or what we call intestate, meaning you have passed away without a will. If you do that, the state law requires that your assets be distributed according to state standards and statutes, despite any intentions or needs of your family. So if you don't plan ahead, the state has a game plan for you. And with public notice, and I love this, a 24-month delay, folks, it can be longer than that. I've gone through estate settlements that have been over a decade. But intestate distributions are processed by the probate court, and the costs are based on the gross value of the estate and are charged to the estate. And they're not cheap. They're very expensive, because once you have to bring in experts, the court says, hey, here's what the statute maximum is. And virtually every individual that gets put into that position, especially if they're a professional that has to be brought in from the outside, they're going to charge the statute limitation amounts. So it can be very, very expensive. Wills do require probate. Okay, your will has to be submitted to the probate court for processing and approval. The will allows you to name your beneficiaries. However, it requires the probate court to administer your assets over time. And the key element of that bottom paragraph is the will does nothing during your lifetime. It doesn't assist during your disability or incapacity either. It just basically does what? It states how you would like your assets and elements to be distributed. What is it? Well, under your state superior court, the probate court administers what's called the probate code. And that code controls an individual's assets at death or incapacity. The case begins with an attorney petitioning the court to make a determination of competency or disability, or to process a will at death. Then the executor or executrix, executor is a male, executrix is female, collects assets and pays debts, fees, and costs, and the remainder of the estate is distributed to the designated beneficiaries. As I indicated before, probate is a public process, and I love this, 24-month delay, and minimum fees are based on the gross value of the estate. But as I said before, 24 months is really only the baseline. Why do people want to avoid probate? Here's the 3 big reasons. And I'm going to start right at the top. Time. Probate court processes take a year or more. As I said before, I have had estates that are relatively complex take over a decade. Costs. Probate fees for executors and attorneys are set based on gross value of the estate without offsets for debt. And lastly, in most instances, a lot of people look at it and say, all this stuff has to be made public? Yes, all probate court filings and hearings are open to the public. So this is one of the primary reasons that people will use a will to dispose of what I'll call simple assets. And in many instances, if they've got a sizable amount of assets, they, in many instances, will use trusts so that it's not made public and their wishes are specified within the confines of those documents. So it eliminates the time element as well. And the costs, you know them up front because they're attached to the ongoing maintenance of those types of vehicles. An additional element you're going to think about is planning for minor children. This is incredibly important because if you leave it to the state, what happens if the crazy uncle winds up being the designated guardian for one of your children? You could be spinning in your grave going, oh my goodness, of all the people, not that person. This is why you want to name your guardians ahead of time. Additionally, are you going to make gifts to minor children? If you do, what are you going to need? You're going to have somebody that's going to have to either fulfill a custodial position or a trustee position for them. That adds potential layers of cost. And then planning distributions of your estate in advance. And one of the key things that I always tell people to think about, especially if you've got minor children, when do you want them to get these assets? Because remember, the age of majority in both New York and New Jersey is 18 years old. So what happens when the conservatorships and these guardianships end? Well, they end at 18 years old. If you've placed a sizable amount of assets for those minors, all of a sudden they've got availability to it. I've had a chance to see how ugly that could be. I had a client who passed away and did not do very good planning. I got them very late in their life, and unfortunately, they had not done good estate planning. We didn't get a chance to get into it more deeply. So a sizable amount was left to his son. His son then went out and bought a brand new Corvette, and within a year, unfortunately, he had killed himself by getting the fastest thing that he could possibly find on the road. I suspect that if his father had given a great deal more thought to it, he probably wouldn't have left those assets directly to him. So one of the key ways that people are going to try and help those minors is they're going to utilize what's called either an UGMA, which is Uniform Gift to Minors Act, or in New Jersey, what's called an UTMA, which is a Uniform Transfer to Minors Act. I'm not going to get into the differences between the two. Fundamentally, they basically work the same. What does the act do? It allows assets to be passed to children under the following conditions. The minor gains full control of the assets at 18 or 21 years of age. As you can see in red, I indicated New Jersey and New York are both 18. Assets are then owned by the minor and they're included in their estate. Here's the other key thing you need to remember. Scholarship applications will typically require that those assets be applied to educational costs first. And they also will be required when you do FAFSA forms. When we talk about minor children, we get into guardians. And there's two elements. There's guardians for the individual person, which could be for a spouse, and it typically is court appointed if you haven't already done so, or guardians of the estate, which administers the assets of the guardian itself, and then probate court gets to appoint who that's going to be, and they will ask for what? Reporting. And when they ask for that, what does that mean? Money. All those components, if you haven't put them in place ahead of time, you can look at each one of these things and think of it as the cash register ringing. And then lastly, as you can see in red, a family trust helps to do what? Well, first of all, the administration gets done what? Without the probate court, because it's a trust. So you can spell out the specific desires and objectives that you have, and those things will all be within the confines of the document. The nice part about that is now the trustee has what? They have a game plan and a blueprint on how to take care of those minor children. So very important to think about those things ahead of time. When we talk about estate distributions to children, guardianship and guardianship estates are entirely distributed at age 18. With a family trust, you establish the specific criteria and the time distributions to children. And you can give the trustee the capability to have what's called sprinkling powers. So they can determine how much they give to those beneficiaries and when. Those are very, very beneficial when we talk about distributions, especially to children. And one of the key elements that you'll probably hear estate planning attorneys talk about is the thing called spendthrift provisions. Why do we typically do that? We don't want to leave sizable amounts of assets to who? 18, 19, 20-year-olds, even 25-year-olds. So in many instances, when we have trusts like this, we will spell out specific elements that those assets can be used for, such as health, welfare, and maintenance, education, so forth. And we will do what in many instances? You'll get so much at 25, you'll get so much at 30, so much at 35, and then typically we do most of our distributions by age 40. Because we're hopeful that by age 40, they at least will have a fairly good understanding of the assets that are coming and how to manage them. But at that point, we can't control them in perpetuity in many instances. So that's the typical, what I'll call timing elements that are attached to spendthrift provisions. They can be more specific than that, but that's the typical ones that we'll see, at least as a starting point. When we talk about wills versus family trusts, distributions of assets by the will are only made at death by the probate court. And it's done, as I said before, with a public hearing. They put a delay of 12 months or more, and costs are incurred. As I said, it can be substantially longer than that. The family trust, however, provides for distributions to your children as needed and at ages that you specify. And it all does what? It avoids probate so that the public doesn't get a chance to see that. That's why you'll see people that have sizable amounts of asset bases typically do what? They have a plethora of trusts in their estate planning documentation because they want to make sure that X goes to this one, X goes to that one, the timing elements, the restrictions, all those components can be put within the confines of the trust. When we talk about planning for your family, let's talk about some of the key elements that people are going to look at. First of all, managing the title to your home, because for most people, that is the biggest asset that they have. And titles can potentially reduce capital gains tax for a surviving spouse if it's done properly. Also, you're going to be planning for both federal estate taxation after the state probate court. And in some instances, you'll also be planning for what? State estate taxes. Most of them will have their limitations set to mirror the federal. That's not the case across the country. There's still a number of states that have unique statutes that are specific to their state that are different than the federal guidelines. And then ultimately, we want to develop some estate tax strategies so that hopefully we can conserve as much of those assets as possible for the heirs. When we talk about titling of the house, because in most instances, this is the largest asset that many people have, you can see that we've got three primary types of titles. I'll stay away from the family trust for a moment. So tenants in common. Tenants in common are essentially multiple owners that have the title of their portion that passes to their heirs. Okay, so for example, let's say that we had a husband and wife, and they may have had a prenuptial, and they decided that they wanted to purchase a home. Let's say that the wife put up a significant amount of the dollars and she owns 80% of the home. Husband owns 20. If she were to pass away, her 80% would go directly to her heirs, not the full 100% or 50%. Whatever the portion is that that individual owns passes on to their heirs. Joint tenancy operates a little differently. Joint tenancy typically comes with what we call JTWROS, joint tenancy with rights of survivorship. Typically, we'll have 2 or more owners, but the title then passes to whom? It passes to the survivors. And it passes entirely to the survivors, okay? Community property, I won't get in depth about community property because we don't live in a community property state. If we were in California, we would talk more about that because husband and wife typically who own that, the title passes to the survivor, but it's a really unique process. And I won't get into it because we don't have anybody that's on tonight's presentation from California. And then lastly, you could have your home titled to your family trust, meaning that the trust would actually own it. If that's the case, do I need to change any titles? No. The trust acts as if it's its own entity. So the best way that I can tell you to think about trust is to think of your trust as what? Another person. You can name them whatever you would like to name them, but think of that trust as another person that has all the rights that you have. So let's talk a little bit about title and capital gains for survivors, because this is where I find people have the least amount of understanding. Capital gains is the tax on the difference between the sale price of a property and what's called basis. So basis is what you paid for it, your actual cost, plus any improvements that you made. So let me give you an example. So let's say that you bought a home for $500,000. You put in $250,000 of improvements and you sell it for $1 million. How much do you have that's potentially exposed to capital gains? Well, if you're married filing jointly, you would have a $250,000 per individual exemption from capital gains for a primary resident. So in that instance, we'd have 0 exposed to capital gains. However, if it's not that type of property, let's say it was an investment property, you put in 500, did another 250,000 of improvements, so you have $750,000 of basis. You sell it for $1 million, you have $250,000 of capital gains that you would have to pay taxes on. Joint tenancy property titles get a step up in basis for the part held by the decedent. The survivor pays capital gains on their half. So what does that mean? Let's say that husband and wife own a home, and let's say that they paid, again, $500,000 for it, and that home appreciated to $2.5 million. The two of them, unfortunately, were killed in a plane crash. That $2.5 million home now gets what? A step up in basis to the current value at the date of death or the alternative valuation date. So there are $500,000 in, it's now worth $2.5 million. What's the taxing implications? 0 for the heirs. They get a step up to the current value of $2.5 million. For community property titles, the entire basis is stepped up and the property may be sold without any capital gains. And again, I won't get into community property. It gets a bit confusing for folks that don't live in a community property state. So you're going to have to plan for federal estate taxes, and you do that after state probate. So you'll need to plan for these federal estate taxation. The estate tax rate increased to 40% in 2016 and 17, with exclusions of 5.4 million and 5.49 million, respectively, in those 2 years. The estate tax rate for 2023 is still at 40%, but the exclusion amount is 12.92 million. Do it properly per individual. So if we have a husband and wife and they have $25 million of combined assets, there's the potential to shelter all of it from the estate taxation. Key element to remember, though, the taxes due in cash within 9 months after death at the rates described above. Let me give you an example of someone that you would think would have done this very well. I'll give you two people. There used to be a stadium in Miami. The Miami Dolphins used to play in a stadium called Joe Robbie Stadium. The Robbie family had to sell Joe Robbie Stadium because Joe Robbie had not done good estate planning. And when those taxes became due, they actually had to sell a good portion of the team and sell the actual stadium itself. Malcolm Forbes, Forbes magazine, the original patriarch, Malcolm Forbes, died without a significant amount of estate planning. And in fact, the calculations post-death were that Malcolm could have saved someplace in the neighborhood of approximately $70 million of estate taxation had he been conscientious about doing his estate plan ahead of time. But what did most people figure? Malcolm Forbes, bright guy, already had it taken care of. Nobody really talked to him about it. And unfortunately, when he passed away, he did not have things set up very well. So this is what the taxation elements look like. And I'm sorry for the little goof on the chart. Every time I try to change it, it changes back to 2018. So the far right-hand column is supposed to say 2023. But as you can see, from 2016 to 2023, we've gone from 5.45 million as an exclusion to 12.92. Here's the great part. If your spouse is a US citizen, you can pass an unlimited amount of assets to your spouse through what's called what? The unlimited marital deduction. You can pass it all. However, you want to be aware of the fact that if you don't utilize your exemptions properly, you may be limited to the 12.92 instead of doing it efficiently and maximizing 12.92 for each individual. Very important to pay attention to this planning. If you're not familiar with these items, please get with an estate planning attorney and they will help to guide you through how to put the right types of pieces in place. Everything from your will to those health-oriented elements, all the way into trusts. So when we talk about estate tax strategies, first and foremost, I'm going to call it family trust because it covers the plethora of different types of trusts that we can go through. And if I sat here and started to list out the different trusts that there are, I'd probably be here for about another 20 minutes before we get through naming all the different trusts that are out there. But the primary reason for them is what? We want to take advantage of the IRS tax exemption, and occasionally we can actually double that if it's done properly. I won't get into the depth of that. That's far beyond the scope of tonight. Additionally, gifts to family and charities. These potentially provide tax exclusions. So, for example, in many instances, when we have family members, for example, we may decide in a trust that we're going to pass specific elements on to those family members. Why? In some instances, we want to try and get these assets out of the estate before we have someone pass. The negative to it is they'll retain the original cost basis. But if we have a very rapidly growing asset and we recognize that it would have been exposed to significant amounts of estate taxation, it may be advantageous to make that gift to your children sooner rather than later and get the estate value out of your estate and into theirs. And then one of the most common elements that's used from an estate planning standpoint is called an irrevocable life insurance trust. The acronym is ILIT. And typically what we do here is we take the life insurance components out of your estate. So if you own a life insurance policy, and let's say it's worth $3 million, and you don't have it in a trust, it gets added into your estate for taxation purposes. So you could potentially be taking a tax-exempt instrument and now making it what? Completely taxable. And if you didn't do good planning, as you can see, if you're over those thresholds, you could pay as much as 40% of that, what would have been tax-free death benefit, now becoming taxable. So the family trust solutions, why do we talk about these things? Well, we want people to think ahead, and we want to try and protect our families as much as possible. So essentially, what do? We transfer title or registration of assets to the trust. The trust then is controlled by what? Either you as the trustee, or you could name someone else as trustee. And in many instances, what do we recommend if that's the case? I want you to put successor trustees in there, and you want to make sure that you pick good, competent people who will be able to make good decisions for the people who have to benefit from that trust. The nice advantage of a trust is it never gets sick. It doesn't become incompetent. It doesn't die. And it can change trustees, and you can put in specific methodologies to do so. There's no need for you to change the title or registration with probate court orders. Why? Because it doesn't go through probate. So how does it typically work? And I love this. We're still using some of the old acronyms, what we call the AB trust. So let's explain how that works. Survivor gets whatever assets are left over. Okay, so we take the survivor's assets and we're going to place those assets into a trust. And this means that whoever the surviving element is, and typically it's a spouse, they get to use those assets any way that they want to. So whatever the amount is that's over the exemption will go into their trust. Whatever the amount is up to the exemption amount goes into the family or B trust. So we've now protected it from further taxation by getting it into that B trust and taking advantage of the exemption amount for that individual. So this is just the beginning elements of doing trust planning. So if you get to this point with your estate planning attorney, one of the things that I recommend to everyone if they're going to do estate planning, when you do your estate plan with an attorney, at the end, a good estate planning attorney will ask you to please explain how the estate plan works. It's very important that you're able to kind of recite that back to your attorney so that he gets or she gets the feeling that you really do understand how this works. And most importantly, when we talk about those trustee positions, you really want to think about who has the acumen and the expertise and the ability to make good decisions before you put them in that role. So why do we use these trusts? Well, first and foremost, we can eliminate the probate court for conservator at any time of any disability or legal incapacity. We eliminate the probate court at death. It potentially can preserve an extra $5 million or more on estate taxes. I won't get into depth as to why that is. And directs the timing and use of the distributions, which in most instances are for whom? The people that you care about, whether it be your children, your grandchildren, special needs type items. If you're going to make philanthropic contributions to different organizations, you can also specify that in the trust. So there's so many things that can be done, but the best way, as I said before, to think of the trust is it's its own entity, okay? And you get a chance to do what? Decide exactly how it's going to work so that your trustee can do what? Administer your wishes. So what are your choices? Well, you can do nothing. And if you do nothing, the probate court will apply the state laws for legacy distributions. So you have a will, even if you don't make one. They'll do it for you. It might not be the way you want it, but they have one for you. Or you can create a will, and the probate court will administer that will, but you're going to add some fees, obviously some time, and it's going to become public. Or you can create a revocable living trust. In this instance, in most instances, the people who are the grantors or the people who make the contributions to the trust will usually also, while they're alive, be what? They'll also be the trustees. If we have an incapacity, it'll be specified what that is and who would take over as the successor trustee in many instances. So your trustee administers your assets in the event of a disability and at death, and literally they can get these distributions within weeks. not years. So it makes the entire process a whole lot more efficient. So what's the basic estate plans that you're going to put together? And I'll just run down them very quickly. You want to put together your will. You may put together a family living trust, but that'll be a decision that you'll make with your attorney. Durable power of attorney. I recommend durable power of attorneys as opposed to what? Springing power power of attorney. Why? Durable power of attorney is put in place while you're cognizant, and we don't have to do what? Wait for something to happen before the specific springing powers now say, oh, now this person has my power of attorney since this springing element occurred. In many instances, as we get older, especially if we have mature children who make good financial decisions and can run our estates in the event that something happens to us, we will typically want to get them named as durable power of attorney early on. And if you have bank accounts and safe deposit boxes, I recommend that you introduce them to the banking representatives. It makes life much, much easier when you go through the distribution stages. If not, try to get into a safe deposit box without a durable power of attorney after somebody's passed away, and you'll see how much fun that can become. Advanced healthcare directives, as I said before, marital property declarations. I won't get into depth as to that. There can be a whole bunch of things attached to that. Nomination of guardians. Who do you want to take care of your children? Or in the event of something happening to you, who would you like to take on that position? And then deed transfer and change of ownership are also things that you want to consider long before you get to the end of the road. So what are the next steps? I tell people, evaluate the benefits of a family trust to meet all of your legal plans if that's something that concerns you in terms of cost and public. The fact that it gets made public because of the fact that you don't have probate, you don't get the delays, you don't have to deal with the public elements. You potentially can double your estate tax exemptions. You can provide for administration at potential disability. It establishes plans for your family needs and distributions. You've done all that ahead of time. People don't have to guess. Okay, it just makes things a whole heck of a lot easier. So as I said, if we were doing these live, I would be asking for an evaluation form. Otherwise, I'm going to say thank you. And I am more than happy to open it up for questions if anybody has some.
We do have some questions already waiting in the chat box, so I'm just going to start reading those out to you. And just as a reminder to everyone at home, you can either put your questions in the Q&A or the chat box. So the first question, I'm confused about an LLC and a trust. I basically want extra coverage, not to be personally sued having a few properties.
Okay. Limited liability corporation essentially does what? The LLC is its own entity. It's not a trust in and of itself. Okay, so the LLC is basically describing who's going to own it. And in many instances, people who have LLCs, what do we find? They name it in a very odd way. Why? Because they don't want people to know who actually owns that. But it doesn't operate like a trust. Your LLC gives the person who owns it the ability to do what? Anything within the confines of those documents, but it's not specifically a trust. It's a limited liability element to do exactly what you're trying to do, which is to remove that exposure of having somebody sue you. But in terms of acting like a trust where you now have the asset sitting in there and it's designed to produce something for someone else, no, that's not the case. The LLC is just, in this particular instance, used from a protection standpoint. Let's see.
Thank you. The next question I have in the chat box, I need help in finding someone to distribute properties. The key word is reasonable.
Okay. So when we talk about distributing properties, there's a couple of issues that are kind of attached to this. First one would be, where are the properties domiciled? So, for example, the state that you reside in is your residence. Okay, and you may have assets that are in other states. So each of those states will require what? You're going to have to go through those distribution processes with each one of those states. In terms of finding someone to distribute it, I always tell people, if you can keep it in the family first and you have someone who has those capabilities, go there first. If not, ask your estate planning attorney whether or not they will step in and fulfill that role. Some estate planning attorneys will, some will not, because they find it to be a distinct conflict of interest relative to them drafting the documents as well. Ones who have high levels of integrity, I'm not overly concerned about, but I think everyone here can see that in today's world, there's a lot of attorneys that don't necessarily hold that standard all that high. And when you say reasonable, the more that you incorporate outside professionals, the more the cash register rings. I'm sorry, that's just how it works. But in terms of finding someone, it's not uncommon if you can't find it within your family. If you have a trusted family friend who has those capabilities, you may want them to do the distribution. You may want them to act as trustee for you in a trust situation, or you may also want them to be your executor or executrix. So it's not a simple answer. Unfortunately, you're going to have to work through that with a good estate planning attorney, because if you've got multiple items like assets in different states as well as this state, you're going to want to work through all those different elements. And that attorney may recommend that you consult with counsel from the specific state that those assets reside in to find out what those specific laws are relative to the documents that you've already drafted.
Thank you. The next question that I have in the chat box: if you fill out a DNR too early, can it work against you? For example, if instead of end of life or disability, you get in a car accident and have a DNR, then you would not be given CPR or other life-saving care. How would you distinguish between when you would want care or not?
If you've got the document, okay, and you've drafted it ahead of time, two things are going to happen. Either you're going to distribute it to the people that you care about, or you're going to have it sitting where? In your home or in wherever you are. If the attorney who drafted that document doesn't know that something happened to you, there is no DNR then, is there? No. So at that point, what's going to happen? Since there's no DNR, they will provide life-sustaining elements. So when we talk about DNRs, you can change your mind, but you want to make sure that if you're putting these pieces in play, that you definitely let your loved ones know, especially the ones who are going to be consulted if you had a car accident or something like that, so that they know that it's there. And it's up to you to review these things, especially with them. I would do it ahead of time so that they understand what your wishes are. If you want to change it, then go back to your estate planning attorney and get it changed.
Perfect, thank you. The next question I have in the chat box: what would be the average cost in this area to consult with an estate planning attorney? Is it a flat fee or by the hour charge? And then the next question actually also has to do with that. Where can I get recommendations for an estate planning attorney?
Okay. First thing, when we talk about costs that are attached to an estate planning attorney, most estate planning attorneys, especially if it's a referral that's coming from me or you have a financial advisor, I'm hopeful that they will have a working relationship. Most of them will basically have the initial consultation as free. Why? They don't know whether or not they even want to work with you. You don't know whether or not you want to work with them. So that's how most of the good estate planning attorneys will orient their practices. In terms of flat fee or an hour charge, most estate planning attorneys in the New York metropolitan area, the lowest levels that I have seen, the absolute lowest would be $350 an hour. I have seen some as high as $1,700 an hour. So it really depends on how complex your situation, whether or not you've got strictly domestically oriented assets, whether or not you've got internationally oriented assets, and do you need specialists attached to that? So sometimes if you've got a pretty clear estate, you may want to work on a flat fee as opposed to an hourly element. So you would have that discussion though with your estate planning attorney up front, and anyone that's worth their weight will have that discussion with you very candidly right up front, so you won't have to guess. But that's the range in terms of pricing. Where could you get recommendations for an estate planning attorney? I tell people to start with at the American Trust and Estate Society, which is through the American College of Financial Planning. They have a trust and estate division. And the nice part about that is you can actually go down there and look on their website to see the different types of estate planning attorneys and what they specialize in. If you've got a real estate attorney, and many people have a general attorney that they work with, the key element to ask them is, do you specifically do estate planning? If they have a list of 25 different things that they do, and estate planning is just one of them, they're probably truly not an estate planning attorney, because most estate planning attorneys, that's all they do. Why? As I said before, I'm studying for my last designation, which is Chartered Advisor of Philanthropy. There's 47 different types of charitable techniques. They can all be intertwined. So you can imagine how complex that stuff gets. Estate planning, same thing. Heavy level of taxation, as well as the estate planning elements. So you want to consult with an attorney and you want to ask specific questions that are of great concern for you, and especially if you have assets that are in multiple states.
Perfect, thank you. The next question that we have in the chat box, does POD bank account subject to taxation or probate?
It says payable on demand, so it's a contractual obligation to do what? Move it from its current registration to someone else. Doesn't have any impact on whether or not it was taxable or not. If it was a taxable situation, it still will retain that taxable element. The only thing that it does is it designates who's going to get it right off the bat without having to do what? Go through the will, because this is a contractual designation. It's kind of like an IRA, an individual retirement account. If you designate beneficiaries, it passes contractually, not via your will, unless you specify who's my beneficiary. The will of whoever you are. Please don't do that. It's the most inefficient way to do it.
Thank you. The next question in the chat. My parents both have wills. Are they not viable or functioning without probate?
Well, if they both have wills, I don't know what the extent of their situation is, but it has to go through probate if it's just wills. It has to. In terms of the question, are they not viable without probate? I'm not quite understanding what the question is from that standpoint. If you have wills, it has to go through probate. So viability from that standpoint, in other words, is the question, are the wills viable? Yes, they're viable, but they're going to have to go through probate.
Thank you. The next question in the chat. I have a will, but need to put the keywords of trust in it. Can I rewrite it by a completely different attorney?
Oh, you can use a different attorney anytime that you want to, and you can change the specifics, not only of your will, but of the trust. There are many elements with regards to wills that will say, I would like my assets to pour over, for example, into this trust, or these assets will now go into this trust upon my demise. So you absolutely can do that. And for many people, they'll start out with who as their first estate planning attorney? Their local real estate attorney. That's the person that they started doing work with. And while they're younger, they want to just make sure that they put the basic elements in place. But as you acquire more and more assets, you may say, that attorney that I did that drafted my original simple will, that's not the person that I really need to do really detailed planning, especially if I've got not only advanced trusts that I want to employ, but I've got a special needs situation or something along those lines. But you can choose an attorney anytime you want to. What I would tell you to do is take your original document to them so they can see what you did initially. It'll give them at least a little information in terms of who you are and the direction that you wanted to head from the beginning, but you can decide to use any attorney that you want to in the future. Absolutely.
Perfect. And the very last question that I have in the chat box, are the wills on the internet valid?
As long as you fulfill the requirements to make them a valid will, meaning that you've got somebody there witnessing signatures, so forth and so on, yes. What's the negative to them? They may not cover all the elements that you want to cover, number one. Number two, there may not be the appropriate, what I'll call outs within the confines of the will or the trust that you've used on the internet, because are you getting any person to sit down with you and help you to devise that game plan? Probably not. A really good estate planning attorney will say, hey, would you like to do X, Y, or Z? And you go, well, I'd like to do the following. And they say, well, you can do that, but you're going to have to do it this way in order for you to avoid taxes if that's your primary objective. Otherwise, what's going to happen? You may not give your trustees enough capability and leeway to be able to do some of the things that you really wanted to do, because you use more of what I'll call a boilerplate document as opposed to something that was specific to you and what you were trying to accomplish. And I see somebody said viable or functioning. So if the will has been drafted and it's a viable will, meaning that it was, you had it attested properly, you had witnesses to it, until it's changed, it's a viable will. Unless somebody comes along and says, wait a minute. The housekeeper that came into the house, within the last 2 years, they talked to my mom and all of a sudden my mom decided to change a whole bunch of things in the will. Then you may have a contesting of that will. Why? Because you've got someone that typically didn't fit within the confines of the normal distribution elements. So you may get a contesting of those types of situations. In many instances, that's why people will use a trust, but I've even seen those elements can be contested, especially if you start to write family members out of the equation.
And I think that that's all of the questions that I have in the Q&A or the chat box. So I want to say a big thank you to everyone for coming out tonight and spending their time watching this lecture this evening. And Mark, I also wanted to say a big thank you to you. Thank you so much for coming out this evening and donating your time to give this lecture.
My pleasure. And as I always let people know, anyone who's attended any of my SOFA events, if you have specific questions, my email's down there. It's mark.lang@lpl.com. You're entitled to an hour consultation. It's something that I do freely with everybody because I would just like to get you pointed in the right direction. If you need further assistance, reach out to me. I'll be more than happy to help you to do that.
Thank you so much, Mark, and have a good evening, everyone. Good night.